at the bottom of your screen. So just click on that and type out your question. Okay. Well, good evening, everyone. Thanks so much for joining us. It's great to see so much interest in such an important topic. My name is Aparna Polavarapu, and I'm the Executive Director and founder of the South Carolina Restorative Justice Initiative. I am also a professor at the University of South Carolina School of Law. The South Carolina Restorative Justice Initiative aims to educate and promote dialogue about restorative and transformative justice and to support the development of restorative practices here in South Carolina. You can learn more about us on our website, SCRJI.org. In addition to tonight's event, we are launching a virtual series on restorative justice that we are very excited about, and you can learn more on the website. But tonight, we are delighted to, along with our co-sponsor, SCCADVASA, which stands for South Carolina Coalition Against Domestic Violence and Sexual Assault, and the University of South Carolina School of Law, to host this conversation with Leigh Goodmark, who will be talking about her recent work, Decriminalizing Domestic Violence, a Balanced Policy Approach to Intimate Partner Violence. So related to restorative justice is this very important question about our criminal justice system, whether it responds to harm adequately, and also what harm it perpetuates or inflicts on others. Tonight's conversation should encourage all of us to think about how we as a society can better respond to intimate partner violence and to serve those who are suffering from it. I already made this comment, but I see more people signing on, so I'm going to say it one more time. I have disabled chat for the attendees. If you have a question, please post them to the Q&A. You are all also muted, so don't worry about background noise. And to get to the Q&A, there's an icon at the bottom of your screen, at the bottom of the Zoom app, that just says Q&A, so you can click on that and type in your questions. We do this for ease of flow of the webinar and also to make things easier for our ASL interpreter. I will also periodically check our live stream on the YouTube page for any questions. Please note that this webinar will be recorded and will be posted on our YouTube page a few days from now. We are talking about a difficult and upsetting topic, so if you need to walk away, you can always come back and watch the recording of this at a later time. Okay, with that, I would like to turn things over to our moderator, Professor Lisa Martin. Lisa is a professor at the University of South Carolina School of Law, where she directs the Domestic Violence Clinic. She has over 15 years of experience working against gender-based violence and brings quite a bit of knowledge to this conversation. And we're very excited to have her join us. So over to you, Lisa.
Thank you. So my task right now is to introduce our two speakers tonight. Leigh Goodmark is the Marjorie Cook Professor of Law at the University of Maryland Francis King Carey School of Law. Professor Goodmark co-directs the clinical law program, teaches family law, gender in the law, and gender violence in the law, and directs the Gender Violence Clinic, a clinic that provides direct representation in matters involving intimate partner abuse, sexual assault, trafficking, and other forms of gender violence. Professor Goodmark's scholarship focuses on intimate partner violence. She's the author of Decriminalizing Domestic Violence, a Balanced Policy Approach to Intimate Partner Violence, and A Troubled Marriage, Domestic Violence in the Legal System, which was named a Choice Outstanding Academic Title of 2012. She's the co-editor of Comparative Perspectives on Gender Violence, Lessons from Efforts Worldwide. Professor Goodmark's work on intimate partner violence has also appeared in numerous journals, law reviews, and publications, including Violence Against Women, the New York Times, the Harvard Civil Rights Civil Liberties Law Review, the Harvard Journal on Gender and the Law, the Yale Journal on Law and Feminism, and Fusion.net. From 2003 to 2014, Professor Goodmark was on the faculty at the University of Baltimore School of Law, where she served as Director of Clinical Legal Education and co-director of the Center on Applied Feminism. From 2000 to 2003, Professor Goodmark was the director of the Children and Domestic Violence Project at the American Bar Association Center on Children and the Law. Before joining the Center on Children and the Law, Professor Goodmark represented clients in the District of Columbia in custody, visitation, child support, restraining order, and other civil matters. Professor Goodmark is a graduate of Yale University and Stanford Law School. We also have with us this evening Sarah Barber, who's the Executive Director of SCADVASA, the South Carolina Coalition Against Domestic Violence and Sexual Assault. Prior to joining SCADVASA, she was the Executive Director of a batterer intervention program that offered services in 17 South Carolina counties. She has 13 years of experience in this field. She has published research on the effects of increased supervision on offender completion outcomes. Current research topics include gender difference in client evaluation tools and the parenting attitudes of participants in batterer intervention programs. She has a master's degree in criminology and criminal justice from the University of South Carolina. We're so glad to have both of you with us this evening, and I'm so honored to be the moderator for this talk. So without further ado, I will turn things over to Professor Goodmark to get us started.
Thank you so much, Professor Martin, and you to the South Carolina Restorative Justice Initiative and to the Coalition Against Domestic Violence and Sexual Assault, and to the University of South Carolina Law School for inviting me to be here tonight. Before I start, I want to tell you that this conversation is very hard for people to hear often. And it's important to me that the position that I come to this conversation from. I have represented people subjected to abuse for the last 25 years. And my interest in this topic is motivated by my day in and day out interactions with a system that I think serves the people that I care about when it serves them at all. And so I'm interested in this not from a defense attorney standpoint, not from an academic standpoint. I am interested in this because this system fails my clients on a regular basis. The argument that I make in my book is that the criminal legal system is not ending intimate partner violence. It's doing very little to stop violence. In fact, it exacerbates many of the conditions that correlate with intimate partner violence, and it has serious unintended consequences for the people that it was meant to serve. And to understand how we came to this place where the United States relies primarily on the criminal legal system to address intimate partner violence, we need to go back a little bit, and I tend to start the story in 1984. There are three things that happen in 1984 that really drive the rush to criminalization as the primary response to intimate partner violence in the United States. The first thing that happens is that the Attorney General's Task Force on Family Violence comes out. And in that report, for the first time, a federal entity, partner violence is a criminal problem. It requires a solution. The second thing that happens is that Tracy Thurman wins a multi-million-dollar judgment against the syndicate after police in Torrington failed to intervene to protect her from repeated assaults by her husband, Charles. As a result of the judgment in Thurman versus City of Torrington, Connecticut, jurisdictions all over the country took notice that the failure of their police to do their job, to intervene on behalf of people who'd been subjected to abuse, could lead them to serious liability. And they were looking for ways to ensure that they would be insulated from that liability. The third thing that happened in 1984 offered jurisdictions a way to be insulated from liability. And it was a study that came out by Lawrence Sherman and Richard Burke that suggested that arrest deterred future recidivist violence. Now, at the time, Sherman, one of the authors, warned that the study needed to be replicated before jurisdictions started to adopt arrest policies. But looking for a solution to the potential liability problem that they were facing, jurisdictions all over the country started to adopt what are called mandatory arrest policies. And I'll talk a little bit more about those in just a moment. Oregon was the first place to adopt a mandatory arrest policy. That was back in 1977, but it's really after 1984 that you see large numbers of jurisdictions across the United States start to adopt these policies. Now let me just explain what I mean when I say criminalization. Criminalization is a couple of different things. First, it's the enforcement of existing laws that should prohibit the kinds of behavior that we talk about when we're talking about intimate partner violence. So the law of assault, for example, which has been with us since the English common law, is part of criminalization. But in addition to existing laws, many states adopted laws that were specific to intimate partner violence, that specifically made violence against a partner a crime or enhanced penalties when somebody committed a crime that involved an intimate partner. But most of the action in criminalization is not around the substantive law. It's actually around process. It's looking at procedural changes. The most important procedural changes is something that I've already alluded to: mandatory arrest. Mandatory arrest simply means that police will make an arrest anytime that they have probable cause to do so. Mandatory arrest took the discretion away from police officers to decide whether a matter was serious enough to make an arrest. The criticism of the anti-violence movement up until that time had always been that allowing police discretion meant that police would simply tell the guy, and at that time it was always a guy and it was usually a husband, to take a walk around the block. But they wouldn't treat intimate partner violence the way that they treated other crimes. Mandatory arrest was meant to change that and to ensure that police exercised their power to make arrests. Not surprisingly, after the adoption of mandatory arrest law, arrest rates went up quite a bit. And the anti-violence community next turned to prosecutors and said, why is it that with arrest rates rising, prosecution rates are not going up? Prosecutors said, we can't bring these cases because we need our star witnesses. We need the person who's been abused, and that person doesn't want to cooperate. A couple of innovations flowed from that realization, or that assertion, I should say. Realization is a strong word to use for something that we don't actually have good research on. But that assertion. One was something called evidence-based prosecution. The idea that you could investigate a crime of intimate partner violence in exactly the same way you investigated a homicide, as though you would not have a victim to testify, by collecting all of the documentary evidence, all of the physical evidence, photographs, all the kinds of things that you would do for a homicide. But the second thing that prosecutors did was to say, we're not going to be bound by what the victim wants in making our determinations about whether we're going to prosecute these cases or not. And that's called no-drop prosecution. No-drop prosecution comes in two varieties. Soft no-drop allows prosecutors to try to persuade people to testify by using things like access to victim witness compensation funds. Hard no-drop, though, allows prosecutors to say, we are going to prosecute any case that we can make, and we're going to force the victim to participate. We're going to subpoena the victim. If the victim fails to cooperate as a result of the subpoena, we might ask the court to issue what's called a material witness warrant for that victim's arrest. And in many jurisdictions, victims have been jailed pending their trials, pending the trials of their partners, I should say, in order to coerce their compliance. And so when we talk about criminalization, we're really talking about both the substantive changes to the law and these procedural changes. All of this was bolstered by the passage of the Violence Against Women Act in 1994. And it's important to situate VAWA as part of kind of an overall ramping up of the criminal legal system. Stakes out the federal government's position that criminalization should be the primary response to intimate partner violence and puts significant resources behind it. VAWA was part of the Violent Crime Control and Law Enforcement Act of 1994. Sometimes you hear it called the Crime Control Bill. And it was the Democrats' attempt at that time to prove that they too could be tough on crime. So then Senator Joe Biden said, for example, Republicans are finding out It is no longer legitimate to say the Democrats are soft on crime as a result of the passage of this major crime bill. What VAWA has done in terms of criminalization is really two things, because VAWA is more than anything else a funding bill. First, VAWA has ensured that criminalization is a funding priority, both in terms of services and in terms of research. And second, VAWA has been used to promote criminalization policies like mandatory arrest. In the first iteration of VAWA, in fact, for states to receive certain kinds of federal funding, they had to have adopted mandatory arrest policies. That has subsequently been softened to require either mandatory or what are called preferred arrest, which say that arrest should be the response, but don't mandate that response. Funding under VAWA has always the criminal legal system. In 1994, when VAWA was first passed, 62% of VAWA's funds went to the criminal legal system. That prioritization has only grown over time. As of 2013, 85% of VAWA funding was going to the criminal legal system. In fiscal year 2017, VAWA's two largest grant programs combined to provide $266 million to the criminal legal system, and that number just keeps growing. Now, all of this would make sense if we had some reason to believe that criminalization was working. And by working, I mean things. One, is it lowering rates of violence? And two, is it deterring intimate partner violence? Now, as to that first question, is criminalization lowering rates of intimate partner violence? You'll hear, for example, Vice President Biden say, domestic violence has dropped 63% since the inception of VAWA. And that's true, but it's misleading because all was dropping over that same period of time. So since 1994, rates of intimate partner violence in the United States have declined significantly. So has all other violent crime. Between 1994 and the year 2000, rates of intimate partner violence decreased at about the same amount as all other violent crime. But what's interesting is that from 2000 to about 2016, rates of intimate partner violence decreased less than the decrease in the overall crime rate. And since 2016, the numbers of incidents of intimate partner violence have increased significantly, as has the number of gun homicides. All during a time when we are putting hundreds of millions of dollars into the criminal legal response to intimate partner violence. We're not even getting the same return that we're getting in all violent crime. So is it working? It's not lowering rates of intimate partner violence any more than the natural drop, and actually less than the natural drop. So is it deterring intimate partner violence? And that's really a complicated question. Studies have failed to find that the existence of laws criminalizing intimate partner violence deters the behavior. I've already told you that the early studies suggested that arrest would deter intimate partner violence, and Sherman warned at the time that those studies needed to be replicated before any policy conclusions could be drawn. The replication of those studies found that for some people, arrest decreased recidivist intimate partner violence. In other jurisdictions, it had no effect at all. And in some jurisdictions, it actually increased rates of intimate partner violence. One study found that the relationship between arrest and future violence is entirely attributable to pre-arrest risk differences in the risk of offending, so that it's not really related to the arrest at all, it's related to other factors. Studies on the deterrent effect of prosecution are similarly problematic. One study found that conviction might have an effect on recidivism, but that effect disappears if monitoring and ongoing accountability are not part of the sentence. Similarly, studies find that incarceration alone has no effect on recidivist intimate partner violence, but that incarceration plus continued post-release monitoring may deter future violence. So the studies seem to show that unless you keep close watch on someone, they are likely to continue to be violent even after having been prosecuted, convicted, incarcerated. Now, this failure to find a strong effect of criminalization may be the product of several different things. It could be that we're not actually criminalizing intimate partner violence. Someone once said to me, "How can you know that criminalization is working? We've never really tried it." And what he meant by that was that the application of the law is still inconsistent. There's not the kind of swift and certain punishment that's necessary to ensure change, that we would have to intervene much more actively and much more often to see any kind of real effect. Recidivism itself is a really problematic measure because it looks at, when we look at recidivism, we look at rates of rearrest. There are lots of reasons why people might or might not be rearrested. Rearrest misses non-criminal forms of abuse that are deeply harmful but not against the law. And if you've already had an experience with the system and found that the intervention did not give you what you wanted, you are unlikely to return to that system again. Add to this the fact that intimate partner violence is routinely underreported. Only about half of crimes of intimate partner violence are ever reported. All of this suggests that these measures are problematic at best, but that people are not being deterred by the existence of the criminal law and these processes. This is not to argue that criminalization does not potentially have benefits. It certainly does. Criminalization, at least as it's currently practiced, is the only way to stop an incident in the moment. Police are the only first responders that we currently have to a violent event. Criminalization can ensure separation of the parties through criminal orders of protection and through prosecution, conviction, and incarceration when those things happen. Criminalization can make resources available to people subjected to abuse, things like victim witness advocates and crime victim compensation funds. And criminalization serves what is called an expressive function, the idea that by saying something in the law, we're showing society's condemnation of that behavior. So having a law that outlaws intimate partner violence says, as a society, behavior. While those benefits exist, I would argue that the costs are exponentially higher. The costs of criminalization include the idea of getting through crime, that we're using the criminal legal system to solve complex social problems, and this is a kind of a critique that goes across a number of different problems. Criminalization does harm to people who've been subjected to abuse, the very people that it was supposed to. I told you that mandatory arrest, after the passage of mandatory arrest laws, rates of violence went up. They went up for women, both in single arrests and in dual arrests where both parties were arrested. Increased interaction with the state has collateral consequences for people subjected to abuse, including increased intervention by the child welfare system. And the operation of these mandatory policies take from people the ability to determine how they want to address the violence in their lives. There are specific harms to people of color. The racism that infests the rest of the criminal legal system is absolutely there in the enforcement of intimate partner violence laws. There's been disproportionate enforcement of these laws against people of color. In one study in Milwaukee County, the study found that 24% of the residents of Milwaukee County were Black, but 66% of the defendants in intimate partner violence cases were Black. There's social stigma, obviously, attached to criminalization, and there are a number of collateral consequences. But there are specific costs of criminalization that actually exacerbate the correlates of intimate partner violence. So, for example, criminalization makes it more difficult to find employment. Having a criminal record makes it much more difficult to find a job. And male under- and unemployment is highly correlated with the perpetration of intimate partner violence. So your inability to find work may then drive violence in your relationship. In terms of community stability, folks who've been incarcerated are frequently released into unstable communities that are challenged by poverty and high unemployment rates. The loss of community members to incarceration weakens community ties and deprives communities of people who should be raising children and contributing to the economy. And community instability is highly correlated with the perpetration and victimization of intimate partner violence. Finally, I want to talk a little bit about trauma. The violence that people experience through the criminal legal system, and particularly through incarceration, is then recycled into their interpersonal relationships. So it's ironic that people who are being punished for violence are sent to a place where they are very likely to be witnesses to or victims of violence. 10 to 20% of prisoners report physical abuse, 10% of state prisoners report sexual abuse, and trauma like that can lead to post-traumatic stress disorder and other mental health issues that people then bring with them into their post-prison relationships. And you will be surprised to hear that experiencing post-traumatic stress disorder, again, is correlated with intimate partner violence. And so there are some very specific costs of criminalization that actually drive some of the correlates of perpetration that we need to be concerned about. So that's really kind of the case I make in my book for why criminalization is flawed policy, why it's so deeply problematic, and why this after-the-fact response is not doing the work that we want it to do. The rest of the book is dedicated to the things that we could be doing. We could be intervening economically. We could be focusing on public health prevention responses. We could be using community-based responses, including restorative justice. And all of that, I hope we'll get a chance to talk about in the rest of the conversation.
Okay, thank you, Leigh. So I'm Sarah Barber. I'm the Executive Director of the South Carolina Coalition Against Domestic Violence and Sexual Assault. And my role here is to really give a brief overview of where I think we are in South Carolina and how the data that we have about the situation in our state may support what Professor Goodmark is saying and how we can possibly move forward. I would like first to say that when we first posted information about this event with Leigh, with the title Decriminalizing Domestic Violence, some people were really upset with us. And I understand that reaction. We know here, however flawed the data, that we have a serious problem with intimate partner and domestic violence in South Carolina. For every year that the Violence Policy Center has released its report, When Men Murder Women, South Carolina has been ranked as one of the most dangerous states in the country to be a woman, with a rate of fatal domestic violence that has been at times double the national average. Last year, the 13 member organizations of SCCADVASA that provide domestic violence services supported over 27,000 victims and survivors. 5,500 of those were provided with emergency shelter, and we know that others were not able to be accommodated in shelter due to them being full. Hotlines answered almost 20,000 calls. Meanwhile, data from SLED reports that police responded to around 27,000 incidents of domestic violence. These are huge numbers that contain devastating individual stories of violence, grief, fear, and lives interrupted. It's also important that we realize that the 27,000 people served by community-based programs are not the same 27,000 who reported to law enforcement. Sort of a Venn diagram of sorts with an overlap of service access in the middle. And then, of course, there's an even greater number who did not report or request services from any system and who may not have told anyone about their experience of violence. Finally, the Centers for Disease Control and Prevention in their National Intimate Partner and Sexual Violence Survey indicates that up to 42.3% of South Carolina women report a lifetime experience of sexual violence, intimate partner violence, and/or stalking. So why then, if the situation is so bad, are we not calling for increased penalties and a larger criminal legal response? My answer to that is that I don't think it's going to help solve this problem. In 2015, a new domestic violence bill was passed by the legislature that did enact these kind of changes. I think some of those were necessary, but it must be noted that we have not seen a decrease in domestic violence in the period following that bill. We also know that there is a significantly different impact on some communities, and specifically the African American community, of increased criminalization and policing. On a national level, the rate of domestic violence homicides has been increasing since 2014. And data from the National Crime Victims Survey indicates that the rate of report of domestic violence to the police has decreased from around 65% in 2010 to around 45% in 2018. So somewhere there is a large disconnect between the remedy that has been put in place and how well it is serving survivors and communities. Some of the people who were upset about this talk also detailed the multiple ways that they had been personally let down by the criminal justice system while dealing with a situation involving domestic violence, how they hadn't been able to find justice or safety within its framework at all. We all know incredibly committed law enforcement officers who have done amazing and life-saving work in this area. We also know individual survivors who have found healing and justice through the system. But there are also many stories of victims who did not get the response they needed or that they thought was helpful. Of 309 respondents to a survey by the National Domestic Violence Hotline who had interacted with the police, only 1 in 5 felt safer, and 2 in 3 said they would be somewhat or extremely afraid to call the police again. And we also must recognize, as Professor Goodmark talked about, that calling the police is only the beginning of a journey through the criminal legal system that the survivor may not want to pursue. Time, money, costs, childcare, work, fear, and love may be among the reasons that prevent their involvement, or may simply have wanted the violence to have stopped in the moment. There are also collateral consequences to engagement, some of which we know, as outlined earlier, increase the risk of violence in the relationship and have widespread community impact. So, knowing all of this in our state, what do we do? I would say that at SCCADVASA, we are really curious. We are interested in looking at, learning about, and carefully thinking through alternatives, of listening and hearing individual survivors and communities speak to their experiences and their needs around justice and accountability. Last week, I saw the words of the poet Lucille Clifton, which struck me as particularly apt for where we are. We cannot create what we cannot imagine. Our current societal vision of justice is limited by our experience of the system we have. It's on our TVs, it's in our movie theaters, it's in the books we read, and most importantly, it's in the lived experience of so many in our community. It is going to take us time to learn what might work, how the current systems, and I'm not just talking about law enforcement there, may change to be more responsive and less harmful, and how we prioritize the immediate needs of victims and survivors around issues such as food, shelter, housing, education, and civil legal resource assistance. The need for this curiosity and willingness to think about new ways has been heightened this year by the focus of the ongoing violence against Black and Brown citizens of our country, and the very real fear that this creates in survivors who may need assistance. And of course, by the pandemic, which is why we're talking through screens, and which is also leading to dramatic increases in the insistence and incidence and seriousness of domestic violence here and everywhere in the world. So after saying that and thinking about curiosity and exploration, I'm going to ask Professor Goodmark a couple of questions to start off that section of this talk. My first question is about concrete steps. I've talked about curiosity and learning, but of course, to make change, you have to take action. Where are you seeing communities take these steps?
There are a number of things that I think are happening as a result of the pandemic, actually, that have really important implications for our capacity to respond to violence in community. One of those things is pod mapping. Mia Mingus in the Bay Area had been talking about pod mapping for quite a while before the pandemic hit in the context of intimate partner violence. The idea of pod mapping is to figure out who in your community can you concretely rely upon and for what. So if you don't want to call the police, if like half of people, you're not going to call the police, who are you going to call? Who's the person in your community that you would turn to, and what can you rely on them for? Who will talk to your partner? Who will give you a place to stay? Who has extra money if you need it? Who will take you and your kids someplace that you need to go? And thinking about pod mapping is one of the very concrete strategies. I think restorative justice is another one of the concrete strategies that people, and I should say restorative and transformative justice, are the concrete strategies that people are thinking about. And that's a really complicated conversation. People talk about restorative justice as though we're simply going to take the criminal legal system and put it aside and plunk down restorative justice and have an alternate system. And restorative justice cannot and will not work that way. Restorative justice requires certain things to be in place before it should go forward, in my opinion, in the context of intimate partner violence. One of those things is that the person who's using violence is willing to accept accountability. We live in a system now where people don't like to do that. And so that may make it more difficult, right, to have restorative justice as a meaningful option. Restorative justice is never going to replace the criminal processing system that we have now. There are about 800,000 incidents of intimate partner violence each year. There's no world in which we're going to do 800,000 restorative processes and think that we're going to be successful in any way or maintain any of what's special about restorative justice. But it is a concrete strategy that we can talk about that communities are employing. We could be providing economic support in a very concrete way to both people who've been harmed and much more controversially to people who are doing harm. But because, and some of the research is gendered, which is, I try to only use gendered terms where the research itself is gendered. But that statistic that I gave you, that male under and unemployment is the single highest correlate with the perpetration of intimate partner violence, suggests that we should be doing something about male under and unemployment, which has been exacerbated horribly by the pandemic. So it's not the least bit surprising that the pandemic has increased rates of intimate partner violence. In addition to being isolated with somebody who might be using violence, you have trauma, you have economic instability, you have all of the things that are likely to drive intimate partner violence. So concrete programs, job training programs, increasing the minimum wage. The Obama White House did a study that showed you could decrease crime significantly if you increased the minimum wage to $15 an hour. So those kinds of structural remedies are really important. I think too often we think about intimate partner violence as an individual issue, when in fact there are huge structural forces that are driving some of this as well that we need to be attentive to. In terms of prevention, there are all kinds of interventions with adolescents, with people who use violence that are working, that we could be putting more of our time and money and attention into to try to prevent some of the behavior that leads to the perpetration of intimate partner violence. Experiencing adverse childhood experiences as a child is highly correlated with both perpetration and victimization. So how do we prevent people from having exposure to community violence, exposure to child abuse and neglect, exposure to intimate partner violence? Those are the kinds of interventions that are going to pay dividends down the road.
Thank you. So I also wanted to follow up on that, and we've listed all the ways that you think these steps could help. And you touched on this a little bit, but I think this needs to bear repeating, is there's always, or very justifiably, a focus on safety when it comes to domestic violence, and a fear that scaling back the criminal legal response will increase danger for victims and survivors. How do you answer the criticisms around your work related to these concerns? And also, how do we keep people on a road to large structural change if there is an incident that goes very badly wrong?
If I thought that the current system kept people safe, I wouldn't say any of the things that I say now. But legal system interventions are after the fact interventions. They are not preventing violence from happening in the first instance. And the research shows us that they are not preventing violence from being repeated either. And so this idea that somehow people will be less safe if we don't have the criminal legal system operating, I think is really questionable. It also assumes that when we intervene using the criminal legal system, that the punishment is such that it's doing something to deter violence. There is a punishment that would deter future violence. You could lock people up for the rest of their lives and then they would not harm their partners anymore. We're not going to do that. We have a huge mass incarceration problem in the United States already. 2.3 million people are incarcerated. If we arrested, prosecuted, and incarcerated every one of the 800,000 incidents of intimate partner violence that we have each year, we would increase mass incarceration by 1/3. That's not a tenable solution to our problems. We have to think about what it is that we're hoping that the system will do when it. So let's start with police. What is it that we actually want from police when they intervene? Do we want them to stop a violent incident in the moment? And that work could be done? And I think it's part of, the defund the police conversation that's going on is all about this idea that there are other ways to accomplish what we think we're accomplishing when we send police officers in. So violence interruption specialists exist in many cities, and they do that stopping the violence in the moment work. And I know from the guys who work in the Safe Streets program in Baltimore, a fair amount of what they do is linked to intimate partner violence, which I found fascinating. But oftentimes when they are intervening in a violent situation, it is somehow, there are people already doing that first responder work. We have first responders who react to violent people in other contexts, in hospitals, through social workers. There's a body of information, of literature, of knowledge that that says there are other people whose skills may be better suited to de-escalating a violent situation. People talk all the time about how these are the most dangerous incidents for police to intervene in. And I find myself wondering a lot, is the fact that someone with a weapon is walking into that situation part of what makes it so dangerous? So I think that's the kind of conversation we need to have. You're absolutely right about what happens when something goes wrong. The first time that someone gets hurt, all of this is going to be called into question. And I've said that a million times in talking about restorative justice, that we have to do it absolutely right, because the first time that it goes even a little bit wrong, we'll never get another opportunity to do it again. And so I think that's why so many people are so thoughtful about doing that work in a way that's thoughtful and productive. But what that ignores is that the legal system is failing every single day. I mean, you pick up a newspaper and you will read about someone who had a protective order and called the police and prosecuted their partner and still ended up dead. The legal system fails to keep people all the time. Why is it that we are continuing this system that isn't asked it to do?
Thank you. And I'm going to hand it back to Lisa.
Thank you. Thanks for this great discussion. So I now am going to pose some additional questions to Professor Goodmark that have been added to our Q&A by the participants today. So the first one is, do you think that the carceral system as we know it can ever possibly rehabilitate people who perpetrate abuse?
The wording of the question is, do I think the carceral system as we know it can rehabilitate? And the answer to that is no, absolutely not. The system is so infested with violence, it causes so much trauma, and it gives so little any kind of rehabilitative service to anyone for me to think that it can do that work. Now, are there places where people are doing extraordinary work with incarcerated people? Absolutely. There's a group, if you haven't seen, for example, the documentary, The Feminist Cell Block Why, like as soon as you turn this off, go watch it. And it's about Richie Reseda and the work that he did with incarcerated guys around feminism and around understanding the work, for example, of bell hooks and how that implicated their own masculinity. Do those programs exist in prisons? Yes. But if you're asking me about the carceral system writ large, a system that is infused with violence, that operates based on violence, that has violence down to its very core, if that's the thing that's going to stop violence, absolutely not.
Thank you. Our next question is, how far would reinstituting a safety net that was deconstructed go toward impacting rates of intimate partner violence?
So not being an economist, I don't think I can give you an economist answer. Real far. I believe that economics are probably the primary driver of intimate partner violence, and our lack of a safety net for all people involved is a significant problem, which is not to say that intimate partner violence doesn't happen among upper income people. Of course it does, but the research is pretty clear that intimate partner violence disproportionately impacts low income people. And so alleviating the strain that comes with economic anxiety, economic stress is absolutely an essential part of this. Having that safety net means two things. First, it means that people who are in relationships that they don't want to be in can get out of them because they have the capacity to do that. They have the resourcing to do that. The second thing that it means is that we alleviate, again, some of that economic stress that's driving the perpetration of intimate partner violence. So I think that our lack of a safety net is absolutely disastrous in terms of rates of intimate partner violence and in terms of the options that are available to people who are experiencing it.
So our next question wonders if you could describe what a restorative justice response looks like on an individual case.
Absolutely. So a restorative response can take any number of different forms. You could use victim offender mediation, which is kind of after the fact, but the one that I'd like to talk about is conferencing, because I think that that's the one that actually has the most promise in terms of getting us away from a carceral system. In conferencing, you have the person who has done, we don't talk about crimes, and we don't talk about kind of criminals and abusers. We talk about a person who has done harm and a person who has been harmed. And in a conference, there's a substantial amount of work done with both the person who has done harm to make sure that they are willing to accept accountability for what they've done, and the person who has been harmed to make sure that this process is what they want and to figure out what they want from it before those two people are ever anywhere near each other. But after all of that prep work gets done by facilitators who, in the case of intimate partner violence, absolutely must have experience with intimate partner violence, knowledge of intimate partner violence. After that prep work gets done, you bring together the person who has been harmed, the person who has done harm, and supportive people from their communities to talk about three questions. What was the harm? What was the impact of that harm? And what needs to be done to redress it? And so for a lot of people, getting to describe the harm is the first time that they've actually been given voice in the process. And then getting to describe the impact of the harm gives the community the opportunity to understand why all of this is so problematic for that person and helps the community to become invested in solutions. The redress piece is absolutely crucial, and it's really, I think, important to understand what the legal system can do for you is so limited in terms of redress. It can't tell you why somebody did the things that they did. It doesn't necessarily give you the right to a dialogue with that person. It may not give you economic support. It may not keep that person away from you on a permanent basis. It may not compensate you for any injuries you've suffered. And it doesn't necessarily restore you in the eyes of the rest of your community. But restorative justice can do all of that. So you can think about emotional reparation as well as material reparation. And in that process, you can create an accountability plan that says, here are the things that you're going to have to agree to do, whether this relationship is ongoing or not. So for people who want to separate, that's who the legal system helps the most, because the legal system is great at separating people. We do it through arrest and conviction and incarceration. We do it through divorce. We do it through protective orders. But for people who want to continue their relationships, people who are going to be co-parenting, even if the relationships end, And people who live in small geographic, religious, cultural communities where they're going to be seeing each other, these relationships need to be reordered in some way. The accountability plan can do that. And it says things like, if X happens, this person, it's kind of like pod mapping in that way. This person is going to be the person who can help. If we decide we're staying together and he or she gets abusive, I can call you and you're going to come pick him or her up and you're going to get this person out of my house. And you're going to call this person on a weekly basis to make sure that they're going to their counseling. And they're agreeing to go into counseling and some kind of intervention counseling to address what they've done. And they're agreeing to pay my medical bills. Having that kind of plan ensures that there's some meaningful accountability. Danielle Sered, in her book, Until We Reckon, talks about kind of this idea that we don't have any kind of meaningful accountability through the criminal legal system because it's a passive accountability. You're not called to actually talk to the person who you've harmed, look them in the face, acknowledge what you've done, and hear what you need to do to make amends. You just get to sit and you get punished, and we call that accountability, but it's not really active accountability in any way. What restorative justice does is active accountability. Now, you have to see the problems here, right? That's time intensive. It's labor intensive. That's why you can't just plunk restorative justice down and say, okay, we've now replaced the criminal legal system. But it's one tool among many that we could be using as an alternative to the criminal legal system.
Thank you. All right, our next question, and we only have time for a couple more, so I'll just forewarn people, I may not get to all of them, but we'll do our best. The next one is, I work as an advocate with the prosecutor's office. I really struggle talking to survivors about moving away from the carceral system. We get survivors who say, I want maximum jail time, or I want him to be locked up. Do you have any tips on how to have a conversation with survivors about comments like these?
I have clients say the same thing. And as somebody who considers himself a client-centered lawyer, I think this is the place where I struggle too. I don't think I have the right to say to somebody, you don't get to want the only form of justice that we currently offer you. But I think when you talk to somebody about what it is that their goals are, what it is that they really want to see happen, the changes that they want made, not the legal outcome, which is I want him to sit in jail forever, but what do you want your life to look like? Then you start to see, well, having him in jail or her in jail is not the thing that's going to get me to the place where I want to be. But I think that as long as the carceral system is our primary response to intimate partner violence, people are going to want it because it's the only justice we offer people. People only understand justice to mean retributive punishment through the carceral system. And so part of our job, I think those of us who don't believe in the carceral system, is to show people that there are other ways of finding justice, that justice can mean lots of different things, and to explore with our clients, what is it that justice really means to you, and how do we help you get there? Are there still going to be people who want retributive punishment? As long as the carceral system exists and we continue to focus on it, absolutely so. But I think at least we can explore these things with our clients to make sure that the justice that they're seeking is the justice that in some form or fashion they ultimately get.
I'm going to ask you two questions at once because they're somewhat related. So the first is that currently in South Carolina, the criminal justice system is the only avenue to ensure that offenders are enrolled in some type of intervention and treatment. What is your opinion of the value of these programs, and should they be accessed to the civil legal system as well? The second question that I'm wondering if maybe you could touch on at the same time is related to restorative justice accountability plans. Who monitors those, and what happens when a plan is not followed?
The research on offender intervention programs is not fantastic, but I think that there are programs that I get excited about. And the programs that I get excited about are the programs that are able to hold two complicated ideas in their hands at the same time. That people can do harm and use violence, and that people may have experienced trauma. So for example, the Strength at Home Men's Program works with combat vets who've experienced post-traumatic stress disorder and then are using violence in their relationships. The fact that they have experienced trauma is not an excuse for what they've done. but it is an explanation. And until we are attentive to the causes of intimate partner violence beyond kind of our general narrative of domestic violence is about power and control, and we really start to think about, okay, but why in this case, why this person? And look at that person as a person, we're not going to make change. So the offender intervention programs that I think are effective, that I am interested in investing in, are the ones that actually look at why people are using violence and try to help make change around those things. And trauma is a big one. In terms of the enforcement of accountability plans, you know, there are different kind of thoughts about this. John Braithwaite, who is one of the founders of restorative justice, if you can say such a thing about a non-Indigenous person, but certainly one of the popularizers of restorative justice, would say that the carceral system actually should be the stick if the accountability plan is not followed. That you get a number of times to try to get to a restorative solution, but if a restorative solution ultimately isn't productive, then you end up in the carceral system. I wouldn't say that because I don't believe in the carceral system. And so I'm still thinking through what does community enforcement of accountability look like? You know, does it mean that you lose the right to be in community with other people? And I think that we're all struggling with that now and trying to figure out exactly what that looks like. When you're in small ethnic, religious, other kinds of communities that actually have some sway over a person, there's leverage to be used there if people fail to carry through on their plans. It may also be that your plan is, I'm going to stay with you, but if you fail to do this, we're going to get a divorce, right? The civil legal system continues to exist even in a non-carceral world.
Thank you.
Lisa, I just want to say real quick, look, I don't have perfect answers for all of this stuff. It hasn't been invented yet. And I think part of what's exciting about these conversations is that we all get to invent it together. That for those of us who are interested in thinking about a different way of approaching these problems, we're working together to figure out what that looks like. And so I'm always excited to engage with all of you to be thinking about, you know, how do we do this better? How do we do it differently?
Thanks, that was a very helpful addition. We are almost at time, and I want to ask one more question, and I'm sorry to folks whose questions I'm not getting to, but if you have a quick response to this, Leigh. The last question is, I'm a public defender. What role can we play in representing clients charged with domestic violence?
Public defenders need to understand the research. Public defenders need to make the case that incarcerating this person is not going to make the violence better. It's going to make it worse because they're going to lose their job. Incarcerating this person is not going to make the violence better. It's going to make it worse because they're going to be exposed to trauma. Public defenders have a really bad rap in our community because you're frequently seen as the people who are kind of pressuring our clients to do things they don't want to do and to say things they don't want to say. And you know, that's a whole other things to think about and talk about. But I do think that this research is helpful in terms of bail determinations, in terms of sentencing determinations, you know, become part of efforts to try to create restorative responses. All of those things I think are really important. But as somebody who kind of trains public defenders from time to time, I think the single biggest thing you can do is to help people understand what you think this system is doing, it's not doing. It's not stopping the violence. So judge, if you want to stop the violence, let's think about other ways to make that happen.
Oh, well, I want to say thank you to everyone. Sorry, I'm going to turn my video back on. Thank you so much for such a thoughtful conversation. I know this hour went by really quickly because there was so much to discuss. And I want to plug two quick things before I end the meeting. I noticed there was some interest in learning more about restorative justice and how it works in this scenario. I would suggest that you check out the restorative justice series we're launching at SCRJI. Again, it's a virtual webinar series that is designed to teach participants about the concepts of restorative and transformative justice, and also dive more deeply into understanding the different ways that these types of justice can be practiced and implemented in different contexts, including intimate partner violence. And the second thing I want to mention is that I'm co-leading a session with Melissa Moore at WREN, the Women's Rights and Empowerment Network here in South Carolina, on September 17th, and we will be discussing community accountability and transformative approaches, including pod mapping. So if that was something that was of interest to you, you should definitely check it out, because we will get into that there. But again, I want to say thank you so much to Leigh for joining us and giving us your time. Thank you so much to Lisa and Sarah for adding your expertise. This was a really fruitful conversation and gave us a lot to think about. So thank you.
Thanks. Thank you so much for inviting me. It was a lot of fun.
Good.